Thus far, in speaking about these stranger cases, I've talked about the relationship between strict liability, negligence, and intentional harms. But there's always another element lurking. Did your particular actions cause the harm in question? The modern view on this subject is to invoke a two-part test. The first is called but-for causation. The second is proximate cause. Under the first part, somebody asks the question, is but for the negligence of a particular defendant or but for the action of a particular defendant, would the harm of the plaintiff happen? And if the answer to that question is no, then the defendant turns out to be out. It turns out this test is simply too capacious because there can be all sorts of events. So if you start with the but-for system, you then always develop a system of proximate cause, a limitation as to what particular injuries that you do cause you're not responsible for, and you develop either a foresight or a directness test. If in fact you do what was said to be in the Roman system, causation corpora corpore, which is fancy Latin for by the body to the body, causation begins with a punch to the face or a kick in the leg. And the connections here are very tight, and everybody therefore understands what's going on, and there's no dispute about it. And so what you then try to do is to go backwards from the immediate cause to see if there's something else in the cycle which you want to take into account. But everybody says that to the extent that you impose coercion upon an intermediate actor, you should be treated as though you're responsible for the harm, as if you did it yourself. And so what you say is actions done under coercion by a third party mean that the actions of the third party are not quote-unquote too remote. Note that at this particular point in time, the definition of proximate cause is oddly contradictory. It started with meaning the closest cause, and now the question is to figure out how remote causes can be held responsible.